Hello everyone. Welcome back to the series where we are discussing about various sections of the Limitation Act. By the time I have discussed section 1 to 13 of the Act, and today we will discuss section 14 of the Limitation Act. Section 14 deals with the exclusion of time of the proceeding bona fide in court without jurisdiction. Section 14 has 3 subsections. First, I'll explain all the 3 subsections of section 14 along with the examples, followed by the conflicting rule of CPC in context with subsection 3 of section 14. And thereafter, we'll discuss the explanations to it. Finally, we will discuss the conditions required to get the benefit of section 14 along with the conclusion and summary. So, let's get started with subsection 1. Section 14, subsection 1 lays down that in computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in court of first instance or appeal or revision against the defendant, shall be excluded, where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court from which defect of jurisdiction or any other cause of like nature is unable to entertain it. So let's not get lost in the complex sentences and understand it in a simple language. So subsection 1 of section 14 simply says that if a plaintiff with due diligence or in good faith, here you have to keep in mind the 2 words, due diligence and good faith. He files a suit or an appeal to a higher court or files a revision in the same court which has no jurisdiction on the matter or any other cause of like nature. In this case, his appeal or his revision or that particular suit will be rejected, as it is very obvious. Then, in such a condition, the time that is lapsed between filing and the rejection will be excluded and will be added in the prescribed limitation period. So, let's understand it with an example so that there is no confusion. Suppose a partition suit needs to be filed. To file a civil partition suit, the limitation period, the prescribed limitation period is 3 years from the date from which the right to sue arises. Suppose the cause of action arises on 1st of January 2020. Then the right to institute the suit will be 1st of January 2023. However, A, an interested party to the suit, files a suit in the court with X jurisdiction, in good faith knowing that X is the jurisdiction on 31st of December 2022. However, on 1st of March 2023, the court dismisses the suit, saying that it does not have jurisdiction over the particular matter. The time period from 31st of December 2022 till the 1st of March 2023 will be excluded and it will be added within the prescribed period of the limitation. Keeping this example in mind, similarly, it is laid in subsection 2, section 14, the same method of calculation will be applied for any application made in the court which do not have jurisdiction over the matter and made in good faith with due diligence. So the only difference between subsection 1 and subsection 2 is simply that subsection 1 deals with a fresh suit, appeal or revision, and subsection 2 deals with a fresh application. However, with this, let me remind you, I have stressed on the words due diligence and good faith. It must be kept in mind that the institution of a suit appeal, revision or an application must be in good faith and after due diligence, as it is a very essential ingredient of the fulfillment of section 14. Moving on to subsection 3, which lays down that notwithstanding anything which is contained in Rule 2 of Order 23 of the Code of Civil Procedure, the provisions of subsection 1 shall apply in relation to a fresh suit instituted on permission granted by the court under Rule 1 of the order, where such permission is granted on the ground that the first suit must fail by reason of defect in the jurisdiction of the court or any other cause of like nature. Again, there is a lot of confusion due to the complex sentences. So there is a confusion because you will find two contradictory provisions of Rule 2 of Order 23 of CPC and subsection 3 of section 14 of the Limitation Act. So for better clarity, let's first take a look of the relevant rules that is mentioned in Order 23. Rule 1, Sub-Rule 3, where the court is satisfied that the suit must fail by reason of some formal defect, or there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of the suit and part of the claim, it may, on such terms as it thinks fit, grant the plaintiff permission to withdraw such suit or such part of the claim with liberty to institute a fresh suit in respect of the subject matter of such suit or such part of the claim. In continuation to this Rule 2, it says, in any fresh suit instituted on permission granted under last preceding rule, the plaintiff shall be bound by the law of limitation in the same manner as if the first suit has not been instituted. Here I repeat that the Rule 2 of Order 23 restrains the plaintiff to take advantage of the time period that he has lost in the suit that he has filed in good faith, but that was not an appropriate jurisdiction for that particular subject matter. So there is no exclusion of such time period according to Rule 2 of Order 23. But as per subsection 3 of section 14 of the Limitation Act, the plaintiff who filed any such suit in good faith, but it has not the appropriate jurisdiction, he made a mistake or after due diligence that this is an appropriate jurisdiction, then after coming to know that it is not the proper jurisdiction, he can take the permission, withdraw the suit and file it in the proper court. And here the prescribed time will include the time that was wasted in the previous suit. And the plaintiff can automatically file a fresh suit with the extended prescribed period. So what do we see? The provision of the Limitation Act will override the provision of the CPC, as Limitation Act is a special provision and CPC carries the general provision. Also in this section it was already written that notwithstanding. So a plaintiff can withdraw the suit and file it in the proper jurisdiction after taking permission from the court. Without permission he cannot withdraw. Let's understand whatever we have learned about this with an example. Suppose the cause of action arises on 1st of January 2020. Then the right to institute a partition suit will be 1st of January 2023. However, an interested party to the suit files a suit on 31st of December 2022, in the court with X jurisdiction, and he has good faith that X has the jurisdiction over that particular partition suit. However, on 15th of January 2023, A gets to know that he has filed in a wrong jurisdiction. A applies to the court to grant permission to withdraw. Applying to Rule 1, Sub-Rule 3 of Order 23 of CPC, the court grants permission to withdraw. Then the time period from 1st of December 2022 till the 15th of January 2023 will be excluded and added in the prescribed period of the Limitation Act. Also, it must be kept in mind by applying Rule 2 of Order 23 of CPC, the previous suit that has been withdrawn will be deemed to be never filed and a fresh suit will be treated as the first suit. Also, it must be kept in mind that this section extends only to filing of the suit and not of the application. Before coming into the explanation part, let's find some questions that might arise during the learning process. The first is Section 14, Subsection 3 covers only suit. Then what about appeal? What is the other cause of action of like nature that is mentioned in Section 14(1) and 2? What about the day of the institution of the suit and the day of withdrawal or the day of dismissal? Are they added in the prescribed period? Let's address the question one by one. Explanation A to Section 14 is excluding the time during which the former civil proceeding was pending, the day on which the proceeding was instituted, and the day on which it ended shall both be counted. So this answers the question that whether the day of the institution of the suit and the day of withdrawal or the way of dismissal will be added in the prescribed period or not. With this explanation, it is very clear that in the cited example that I have provided, where the institution of the suit and the decision day or the withdrawal day will be added in the prescribed period. Explanation B. A plaintiff or an applicant residing in appeal shall be deemed to be prosecuting a proceeding, which answers the question that whether Section 14 subsection 3 covers only institution of suit. No, it extends to appeal as well, because it is clearly mentioned here that appeal will be considered as an institution of the suit for this purpose. Explanation C. Misjoinder of parties or cause of action shall be defamed to be a cause of a like nature with defect of jurisdiction, which answers that the other cause of like nature which is mentioned in Section 14 and Section 2. However, to get the benefit of the section, the following conditions are to be satisfied. Both the prior and the subsequent proceeding are the civil proceeding which is prosecuted by the same party. It means that the provision is not applicable for the criminal cases. And secondly, the party has to be same in both the circumstances. The second point that we come to know is the prior proceeding has been prosecuted with due diligence in good faith, which means that the mistake of the party he had no idea and he had instituted the suit in good faith. This is a very important ingredient. Thirdly, the failure of the prior proceeding was on account of the lack of jurisdiction of that particular court or any of like nature, which is explained in explanation C of Section 14. Fourthly, the prior proceeding and the latter proceeding shall be of like nature. Now we can conclude that the provision of the section is to afford protection to the litigant against the bar of limitation when he institutes a proceeding which by reason of some technical defect cannot be decided on merits and is dismissed. But when the party seeking the benefit of this section has failed to get relief in the earlier proceeding, does not amount to the defect that it is in section 40. So, and the other cause of like nature is already explained in the explanation C. When the plaintiff has concurrent remedies and has availed one remedy and have become unsuccessful, he cannot take the benefit of section 14 when institute the alternating remedy through section 14. It does apply to an appeal. Further, the benefit of this provision is not available in the criminal proceeding. Execution proceeding is a civil proceeding within the meaning of section 40. The primary requirement of seeking the exclusion under section 14 is the matter was prosecuted before the court suffering from the defect of jurisdiction. Due diligence in good faith must be established, and it is a very important ingredient, and the onus of proof is on the plaintiff. The definition of good faith is given in section 2 subsection 4 of the Limitation Act, which requires the thing to be done with due care and attention. Section 14 will not help a party who is guilty of negligence, lapse or inaction. The section also does not apply where a previous suit was abandoned or withdrawn by the plaintiff and then a fresh suit was filed after the limitation period, that is the extended limitation period. So with this we come to the conclusion, and I think this video has helped clearing all your doubts regarding section 14. See you again in the next video with the proceeding sections of the limitation.